Hello everyone, I'm Anuj Nakade and you're watching LiveLaw. In this video, we bring you another case involving the Prevention of Money Laundering Act or the PMLA. Yesterday on the 16th of May, the Supreme Court pronounced its judgment in a petition about the cash for job scam in Tamil Nadu. The story starts in 2014. The Metropolitan Transport Corporation, a company owned by the state of Tamil Nadu, was recruiting several drivers, conductors, junior tradesmen and engineers at several posts in the state of Tamil Nadu. But after the selection list was announced in 2015, it was alleged that various officials of the Transport Department colluded jointly and separately, including the then Electricity Minister and Transport Minister Senthil Balaji. It is worth mentioning that Mr. Senthil Balaji is also the current Electricity Minister and the Prohibition and Excise Minister of Tamil Nadu. Then in 2018, a person named K. Arulmani filed a complaint against Mr. Balaji and others for taking bribes on the false promise of appointing them to various posts in the Metro Transport Corporation. In 2014, Arulmani was a part of the technical staff and was allegedly told that the influence of the then Transport Minister can be used to get a job in the company in exchange for a sum of money. He also made an allegation that Arulmani collected Rs 40 lakh from a number of applicants and aspirants and paid it to another person who received it in the presence of Mr. Balaji. However, after all this, none of the people who paid the accused to secure their jobs actually found their names in the selection list, nor were their money returned. Following this allegation, an FIR was registered against Mr. Balaji in 2018 and Mr. Balaji and other officials were arrested for criminal breach of trust, cheating and criminal intimidation. The proceeding for this case was then ongoing before a special court for members of parliament and members of the Legislative Assembly. But the Madras High Court quashed this cheating case before the special court in 2021 after being told that the complainant and 13 alleged victims had reached a settlement with the accused. The FIRs in the other case were also subsequently stayed because of the joint compromise memo that cemented this settlement. At the same time, Mr. Balaji received a summons from the Enforcement Directorate in Madurai in connection with the cash for job scam. Mr. Balaji then challenged the summons issued by the Enforcement Directorate before the Madras High Court, saying that there are no facts to initiate any proceedings under the Prevention of Money Laundering Act. The Madras High Court then quashed these summons issued by the ED as well. Then, the Enforcement Directorate approached the Supreme Court in 2022, challenging the Madras High Court's decision to quash the summons by ED. The Supreme Court set aside the order of the Madras High Court and reinstated the criminal complaints against Mr. Balaji. Not only that, but the Supreme Court also issued directions to include crimes under the Prevention of Corruption Act in the proceedings. Later that year, in November of 2022, a fresh inquiry into the matter was ordered by the Madras High Court. After observing there were irregularities in the investigation conducted by the investigating agencies at the time, Mr. Balaji and all other accused in this case then filed an appeal against the order of the Madras High Court in the Supreme Court. There were also appeals filed by the Enforcement Directorate, some of the alleged victims in the cash for job scams, and anti-corruption NGOs. These appeals against the Madras High Court raised a lot of fundamental questions about the nature and implementation of the Prevention of Money Laundering Act. Most importantly, one of the things sought by the former minister was to refer the case of Vijay Madan Lal Chaudhary to a larger bench. The Supreme Court in the Vijay Madan Lal Chaudhary case had upheld the constitutionality of several provisions of the PML Act, specifically the ones relating to the powers of the Enforcement Directorate regarding power of arrest, power of attach, searching and seizing the property of the people being investigated. Coming back to the cash for job scam and the Supreme Court's proceedings in it, a two-judge bench of Justice Krishna Murari and Justice V. Ramasubramanian heard this matter and passed an order yesterday on the 16th of May. The Supreme Court has set aside the order of the Madras High Court to start a fresh investigation and refused to refer the Vijay Madan Lal Chaudhary case to a larger bench. The Supreme Court stated that a reference to a larger bench in this judgment will bring a pending investigations under the PMLA to a grinding halt. Even more importantly, the Supreme Court has issued a notice in a review petition in the Vijay Madan Lal Chaudhary case under the prima facie observation that two aspects of the judgments require consideration. The first is not providing the accused with a copy of the ECIR, and second, reversal of the burden of proof of the presumption of innocence. The court has refused the accused persons the opportunity to piggyback on the review petition and dodge their culpability under the Act, according to the court. The court has also made a declaration that the receipt of a bribe is also an act of money laundering under the Act. The Supreme Court says that the registration of an FIR in a corruption case is sufficient to launch an ED probe. The court has clarified that criminal activity that generates proceeds of crime are like Siamese twins, joined to each other. One cannot go without the other. In case of the offense of corruption, the acquisition of the proceeds of crime in such cases would itself be money laundering. The court said, and I quote, "It is true that there are some offenses which, though scheduled offenses, may or may not generate proceeds of crime. For instance, the offense of murder punishable under Section 302 is a scheduled offense. Unless it is a murder for gain or murder by a hired assassin, the same may or may not generate proceedings of crime. It is in respect of such types of offenses that one may possibly argue that the mere commission of the crime is not sufficient, but the generation of proceeds of crime is necessary. In the case of an offense of corruption, the criminal activity and the generation of the proceeds of crime are like Siamese twins. Therefore, even if an intangible property is derived as a result of criminal activity relating to a scheduled offense, it becomes proceeds of crime under Section 21U. Where there are allegations of corruption, the acquisition of proceeds of crime itself tantamounts to money laundering. We should remind you that we do a significant number of cases about the Prevention of Money Laundering Act and regularly explain concepts like scheduled offenses and proceeds of crime. If you'd like to watch those videos, you can watch them in the cards right here. That's all we have for you in this video. Hope you found the video informative. If you think we should do a detailed video about the Prevention of Money Laundering Act, please let us know in the comments. We will also leave a link down in the description to the full article and the judgment for your reference. Don't forget to subscribe to our channel and hit the bell icon for notifications. Thank you.